Officer Jackson. However, or Detective Jackson, I just don't think that at this point, based on the time frame, that I can not give relief. Obviously, I think that the lack of criminal history is important. So that goes into this, because if we've got any type of criminal history, we'd be looking at something a whole lot different. I don't disagree with Ms. Malfino about what's going on in Jefferson County, but I also have to individualize each case. Charged with the offense of murder. The case has been filed and not indicted yet. Mr. Burbank was appointed to represent Mr. Stansberry. Ms. Holmes has joined in just with regard to filing an application for writ of habeas corpus seeking a bail reduction. And so we set it for this hearing. Mr. Stansberry's bond is currently set at $1.5 million. And Ms. Holmes, you may proceed.
He does have family here who will make sure that they secure his presence. Just briefly, although we don't have all the information, I can say from what I do know that in regards to this particular case, Mr. Stansberry did not flee. He's actually the one who called 911 after this had occurred. He was cooperative with law enforcement and provided his statement of events and everything that happened. So I do believe that that is a mitigating factor for the court to put into consideration, that we do not believe that he will be a flight risk if the court reduces his bond to a reasonable amount to allow him to bond out. Since this has occurred, Mr. Stansberry has lived in the area since 2020, in which he was relocated from a hurricane, in which he moved with, at the time, with his children, who do reside here in Beaumont with their mother, in which they share joint custody. Since this has occurred, Mr. Stansberry has lost that apartment, where this occurred at his apartment. If he is allowed to bond out, he does plan, or is in hopes of planning, to live with his current girlfriend, who's here as well, with his parents. She lives at 25419 Richton Falls Drive in Richmond, Texas.
I think there is going to be a dispute with respect to an affirmative defense versus an intentional and knowing murder. I don't disagree with that. I think the sides are not in the same position right now, but it's kind of hard to read between the lines with a 3-sentence probable cause affidavit. I think based on what this court has done recently, and based on just on the fact that every single weekend we turn on the TV and there's a murder in Jefferson County, I think that bonds in this county to protect this community, understanding of the defendant's rights, need to be substantially more than they have been in the past. And I think the court is beginning to follow, at least this court, is that trend. I'm not saying that an amount of relief is necessarily opposed by the state, but I don't believe, just based on what I know, Judge, and based on everything we're dealing with in this community, that something as low as $200,000 would be sufficient at this point.
My biggest concern at this point is the fact that this is from November 7th and you guys don't have it yet. And I think obviously the nature of the offense is we're tired of hearing about these offenses. It's the worst offense we can have. However, I mean, everybody has the right of being presumed innocent, you know, and we've got somebody sitting here for 30 days without a case even in your office, much less indicted yet. And I think that's a big problem that needs to be addressed. And so that puts you guys in a bad position as well, Ms. Malfino. I think the facts are somewhat important, and I wouldn't mind hearing from Officer Jackson. However, or Detective Jackson, I just don't think that at this point, based on the time frame, that I can not give relief. Obviously, I think that the lack of criminal history is important. So that goes into this, because if we've got any type of criminal history, we'd be looking at something a whole lot different. I don't disagree with Ms. Malfino about what's going on in Jefferson County, but I also have to individualize each case. So that being said, I'm going to grant the relief. I am going to reduce the bond in this case to I'm going to reduce the bond in this case to $500,000. Mr. Stansberry will be ordered to live in Richmond, Texas at 25419 Richton Falls Drive with Ms. Starks. Will be required to wear a GPS monitoring device and be on house arrest, other than for coming to court and for visiting with your attorney. Without my permission, you don't go anywhere else if you make that bond. If you've got doctors, if you've got different things like that, you get with Ms. Holmes, she gets with me, or Mr. Burbank, either one, they get with me, and then I either give you permission for that or not. Other than that, you're on house arrest with the GPS monitoring device. We'll know immediately if you leave the house without permission. The bond will likely be what it is now, if not more, if that happens. Are there any specific, I guess I don't really need to worry too much with a no contact, or because I'm going to have him on house arrest if he makes the bond. But obviously you're not allowed to be anywhere near that old address or anywhere near anyone who was involved that night. You're not to have any communication with anyone involved. So that all doesn't just mean contact in person. It means you can't talk to them, send message to them, anything at all. What were you?
Judge, I just wanted to ask the court to consider, for what it's worth, the order that he not possess a firearm or be in a home with any firearm. And also,
Yes.
I don't know how to request that you order this, but I would prefer, and I think it would be beneficial to the court and to the fact that this is a Jefferson County jurisdictional issue, if he obtains that GPS before he leaves here, so that
They'll put it on before he won't be able to leave jail without it.
somebody we work with, such as Johnny's, would be able to keep the
No.
court informed of this.
It has to be, when we order a GPS, it's part of them getting out of jail. They don't get out of jail until they come put it on their leg there, I'm pretty sure. And so, isn't that how it works on GPS? I know not on drug patches, but GPS, they go put them on.
Before they get out.
Yeah, okay. So that gets taken care of through the bondsman, and they get somebody to get that done upon leaving or checking out or whatever happens there. Okay, so you are ordered not to be in possession of any firearm. If there are firearms in the home of Ms. Starks, they all need to be removed. So if you're going to live there, then you're technically in possession of that place. You can't have any firearms there. Makes sense? And Mr. Williams, in cause number 25, DCCR 1254, you're charged with the state jail felony offense of evading arrest or detention with previous conviction. That is from August 14th of 2025. The indictment alleges that you were previously convicted of evading detention in Harris County, June 4th of 2007. And so that prior evading is what makes this a state jail if you were found guilty. Your indictment further alleges that you were convicted of the offense of burglary of a habitation with intent to commit theft, a second-degree felony, February 1st of 2006 in Harris County. And then after that was final, you were convicted of aggravated assault with a deadly weapon, a second-degree felony, December 10th of 2009, also in Harris County. If those two prior convictions are true, then what that means is if you go to trial and you're found guilty, then the range of punishment would be enhanced to that of a second-degree felony, which means your minimum punishment would be 2 years in prison up to 20 years in prison. Do you understand? Okay. And so I know you've talked with Mr. Lewis about what I'm sure the state's offer is, and do y'all have an announcement?
I'm just not clear. I mean, the state jail felony is being enhanced
Yes,
now.
correct. Yeah, so if you, the way it's indicted, and if those prior convictions are true, if you were actually convicted,
Yes, ma'am.
and you were convicted on different dates, like it says,
Yes, ma'am.
then this becomes a second-degree felony for punishment purposes. So whether you go to a trial or whether you negotiate, the only way for it not to be is if the state elected not to go forward with that, and that is completely up to them. And if they have given you an offer that does not do that, then that's what the offer is. You either take that offer or you go to trial, knowing that if a jury finds you guilty, what that range of punishment is 2 to 20, not the state jail. Do you understand?
Yes, ma'am.
Okay. Do you want to talk some more to Mr. Lewis about your options, or do you know what you want to do?
What was it? 4 years TDC?
I'll hold it. Y'all go visit for a few minutes and just let me know if you need more time or anything. All right, sir. You're Derek Williams, right? Mr. Williams, you were given an opportunity to visit again with Mr. Lewis about what your position is with regard to what we went through. The possibility, if you go to trial, is potential for 2 to 20 in prison if you're found guilty, and that the state had offered a 4-year term if you wanted to enter a plea of guilty. And so what do you want to do?
Trial.
You want to go to trial. So there's a rejection that you need to sign with Mr. Lewis. Y'all get that signed. I'll call you right back up here and we'll get your case set for trial. I do want to make sure you understand, though, I mean, I know we already went over this, that this offer will not be accepted after today. If you're not guilty, that's fine. That's what juries are for. But I don't want you to think by putting this off, you're going to get some better deal.
No.
Okay. All right. I'll hold it while y'all do that. I'm sorry?
So I was hoping to reach a plea deal today, but
Well, the offer is what the offer is.
understood.
Okay. You're Derek Williams. And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
So we're going to go through the indictment again because it's required. Mr. Williams, you're charged with the state jail felony offense of evading arrest or detention with previous convictions. And that is from August 14th of 2025. The indictment alleges you were previously convicted of evading detention June 4th of 2007. It further alleges that you were convicted of burglary of a habitation with intent to commit theft, a second-degree felony, February 1st of 2006. And after that was final, you were convicted of aggravated assault with a deadly weapon, a second-degree felony, December 10th of 2009. How do you plead to that charge?
Good.
And are those prior convictions true? And did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with. I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
I do.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State Tenders Number 1.
Move it.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with previous convictions. Find those other 2 prior offenses true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff.
Thank you.
It's not accurate. It's not an aggravated.
No, sir. And will your client waive the formal reading of the indictment in each case? Mr. Robertson, in cause number 25 DCCR 0498, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from March 23rd of 2025. The indictment alleges you were previously convicted of evading detention February 23rd of 1998, and then again January 10th of 2000. And then it further alleges you were convicted previously of possession of a controlled substance, a state jail felony, April 22nd of 1999. Then after that was final, you were convicted of delivery of a controlled substance, a state jail felony, November 20th of 2000. And then after that, possession of a controlled substance, a state jail felony, November 4th of 2003. And then convicted of two delivery of controlled substance, state jail felonies, June 13th of 2005. After that, convicted of possession of a controlled substance, a state jail felony, February 19th of 2008. Again, convicted of possession of a controlled substance, a state jail felony, April 12th of 2010. And unauthorized use of a motor vehicle, January 7th of 2010. And then finally, possession of a controlled substance, a state jail felony, July 29th of 2024. And how do you plead to that charge? Are all of those prior convictions true? Did you enter your plea of guilty and true to all of those convictions freely and voluntarily?
Yes.
And because they're all actually true?
Yes.
All right, I do want to know, what was that what did he get last year? Possession of a controlled substance, July 29th, 2024. Cause number 24, DCCR 0025.
State jail. State jail, Your Honor.
State jail time?
Second. Yes, state jail.
Okay. You ever been to TDC on any of these cases? So you understand if I follow that agreement, you're waiving your right to appeal, right?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Robertson is not competent?
No, Your Honor.
And the agreement is for a dismissal in 0499, correct?
No, there's two cases.
Two cases, Judge.
What did I just read?
CC.
Oh, to run CC, sorry. Let me go through. So then, that helps me. Hold on, I gotta write this. All right, in cause number 25, DCCR 0499, you're charged with, give me a second, the state jail felony offense of burglary of a building from March 7th of 2025. This indictment alleges all of those same prior convictions that I read out previously. And how do you plead to this charge? And again, are all of those prior convictions true?
Yes.
And are you entering your plea of guilty and true in this case freely and voluntarily?
Yes.
State tenders number one in that case as
No
well.
objection.
It's admitted. Any evidence that Mr. Robertson's not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. And cause number 25, DCCR 0498, find you guilty of the state jail felony offense of evading arrest or detention with previous convictions. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0499, also find that you entered your plea of guilty freely and voluntarily, and those pleas of true. Find sufficient evidence to find you guilty, and at this time find you guilty. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you, in each of those cases, the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. They will run concurrently, which means together at the same time.